Hello and welcome to our webinar on the CG Fry judgment in the Supreme Court. My name is Charlie Banner KC of Keating Chambers, and I was the leading counsel for CG Fry, the successful appellant in the Supreme Court.
Good evening, everyone. My name is Zack Simons KC of Landmark Chambers, and I led the case on behalf of one of the two of the interveners, both the LPDF, which is the Land Planning and Development Federation, and also the HBF, the Home Builders Federation, in the Supreme Court.
Hello, good evening. I'm Ashley Bowes. I'm also a barrister at Landmark Chambers, and I was junior counsel to the appellant.
Good evening. My name is Henderson. I'm also a barrister at Landmark Chambers, and I was junior counsel both to the appellant and to the interveners, HBF and LPDF.
Thanks all. Well, we're going to cover four titles for you this evening. We're going to start with an introduction, background and summary of the court's findings, which I will lead on. Then Matt's going to discuss what the court found in relation to the habitats regulations and the implications of that part of the judgment for other cases. Zack is then going to discuss what the Supreme Court found in relation to material considerations at the discharge of condition stage and what that means for future cases. And then Ashley will explore what the Planning and Infrastructure Bill, currently before Parliament, in fact being debated right now in the building I'm in, would mean for all of this. So turning firstly to the introduction, background and summary, well, the headline, as many, if not all viewers will know by now, is CG Fry were successful in their Supreme Court appeal. They managed to persuade the Supreme Court that appropriate assessment of their Jurston Farm development's effect on phosphate pollution in the Somerset Levels Ramsar was not required in relation to the pre-commencement conditions, which required approval of certain details which had no implications for phosphates. The background is that planning permission was granted for Jurston Farm, a large multi-phase development, as far back as 2015. Reserved Matters approval for Phase 3 was granted in 2020, and that Reserved Matters approval contained pre-commencement conditions requiring approval of certain minutiae such as street furniture, tree root protection zones during construction and the like. CG Fry applied to discharge these pre-commencement conditions in June 2021, and the council declined to determine them on the basis that an appropriate assessment of the impact of the development on the Somerset Levels Ramsar as a result of phosphate pollution from water was required, and following advice from Natural England, adverse effects on the integrity of the Ramsar couldn't be ruled out in the absence of a nutrient neutrality scheme which wasn't at the time available. And secondly, the council's position was that the effect of Regulation 63 of the Habitats Regulations, as applied to Ramsar sites by planning policy in the NPPF, was that the conditions could not be discharged even though they concerned matters which had no phosphate consequences. CG Fry appealed to the Planning Inspectorate, and following an inquiry in August 2022, the inspector dismissed the appeal, agreeing with the council's position. CG Fry then challenged the inspector's decision by way of a claim for statutory review under Section 288 of the Town and Country Planning Act 1990. And in June 2023, Sir Ross Cranston, sitting as a judge of the High Court, dismissed the claim. The case then went to the Court of Appeal, and in July 2024, the Court of Appeal, Sir Keith Blimbron, Lord Justice Singh and Lord Justice Ardles also dismissed the appeal. But 3-0 down, CG Fry were not deterred, and they proceeded to the Supreme Court. Now, in the context of the High Court litigation, the Home Builders Federation provided a witness statement in support of the claim, which evidenced the extent of the impact of the issue before the court. And that evidence was that several thousand already consented homes in Somerset were being held up by the insistence of government, both at central and local level, that appropriate assessment of the whole development on the Ramsar was required before pre-commencement conditions could be discharged, and in the absence of a nutrient neutrality solution, they couldn't be discharged, even though they had nothing to do with phosphates. So that was the extent of the impact of the issue. Now, before the Supreme Court, there were two grounds of appeal. Ground one was that the habitats regulations did not require or enable, in this context, appropriate assessment at the discharge of conditions stage as a prerequisite for consent being granted. And the analysis was, broadly speaking, that Regulation 70 of the Habitats Regulations expressly only applied to planning permission, not to discharge of conditions. And Regulation 63 of the Habitats Regulations was expressed to be applied under Section 62, quote, subject to and in accordance with Regulation 70 in relation to planning projects. And so it was said there was no scope for a purposive interpretation so as to apply it to discharge of conditions, because that would not be applying Regulation 63 subject to and in accordance with Regulation 70, but in a different way. It was also said that similar language had been used previously in the context of the original 1980s EIA regulations, and following the European Court of Justice in Barker finding that EIA needed to be undertaken in some circumstances at the reserved matters stage, the remedy in the House of Lords in Barker wasn't a purposive interpretation of the EIA regs, but a declaration of incompatibility. Ground 2 was that Ramsar sites are not protected in any event by the Habitats Regulations. They fall out with those regulations. And the way it was said by the government and the local planning authority that the Ramsar site did require appropriate assessment was that planning policy, now enshrined in paragraph 194 of the framework, the numbers changed recently but the substance hasn't, that provision said that Ramsar sites should have the same level of protection as habitat sites. And what CG Fry said is that that was all very well and good, but policy cannot make legally relevant that which is legally irrelevant. Policy can't change the law. The government sought to meet that argument by submitting that at the discharge of condition stage, the range of material considerations are actually the same as at planning permission stage, because the consequences of discharging a pre-commencement condition were to allow the development to proceed. And on that basis, they said that the phosphate consequences of discharging the tree protection zone, street furniture conditions were all along legally relevant considerations, and therefore the NPPF wasn't making legally relevant that which was legally irrelevant. Well, on that second point, the Supreme Court disagreed with the government and it allowed the appeal on ground 2. It agreed with CG Fry's submission that the effect of the development on the Ramsar site was a legally immaterial consideration in the context of the conditions in question. It couldn't lawfully be taken into account. And the NPPF, paragraph 194 as it now is, could not make material that which was legally immaterial, because that would be lawmaking by policy. Under Ground 1, the Court agreed with the Secretary of State's submission that Regulation 63 of the Habitats Regulations could be purposively interpreted so as to apply the requirement for appropriate assessment to the discharge of condition stage, but this was academic in the present case because the Somerset Levels Ramsar is not a European site protected by the regulations, but a Ramsar site. There are European designations in the Somerset Levels, but the evidence was that they weren't adversely affected to the relevant standard by nutrient neutrality considerations. It was only the Ramsar that was. Therefore, over 4 years after CG Fry applied to discharge the pre-commencement conditions, over 3 years after the inquiry, and indeed over 5 years since their reserved matters approval was granted, following 4 rounds of litigation, they have finally been vindicated. And now over to Matt to discuss Ground 1 in a bit more detail.
Thanks, Charlie. So the issue under Ground 1, as Charlie's already alluded to, was one of overarching principle on the interpretation and indeed application of the Habitats Regulations, namely whether Regulation 63 requires an appropriate assessment to be undertaken before local planning authority decides to discharge conditions requiring the approval of reserved matters in a grant and outline plan permission. And the answer to that issue is yes, it does. And that was a decision which is entirely in accordance with what the Court of Appeal held before. And so in that respect, there's been no change in the law. Why did the Supreme Court find that the appropriate assessment provisions were applicable? Well, 3 key reasons. The first reason relates to Regulation 70 of the Habitats Regulations. As Charlie's already alluded to, those are regulations dealing with the application of the assessment provisions to the decision to grant plan permission. And the Supreme Court found that it's correct to say that Regulation 70 is one which is expressly directed at that decision to grant plan permission. But just because it's expressly directed at such a decision doesn't mean that it precludes the application of the assessment provisions to other decisions within a multi-stage consenting process. Second key reason was because Regulation 63 is one which is in general terms, so for example it uses the language any consent, permission or other authorisation, and that general language was, in the view of the Supreme Court, sufficiently wide to capture a subsequent decision such as a decision to discharge conditions requiring the approval of reserved matters, because that is another step in the multi-stage consenting regime which was within those broad words used in Regulation 63. And importantly, that is one of those decisions which is essentially, to use some of the European case law, an implementing decision. Although you've got your granted plan permission, which certainly in our domestic sphere is the critical and all-important decision, within the stream of the habitats regulations and taking into account this European jurisprudence, that subsequent decision, the discharge of conditions decision and dealing with those approval of reserved matters, is itself an implementing decision and thus within the scope of Regulation 63. And the third reason was because applying the precautionary approach, which the Supreme Court considered to be an interpretive principle that applies here even to these domestic regulations because of their genesis from European jurisprudence, applying that precautionary principle, the decision that the appropriate assessment could be required was one which accorded with that underlying purpose to the regulation. So for those three reasons, in common with the Court of Appeal, on the first issue, an appropriate assessment can be required at the discharge of condition stage, and there's no change in the law, and therefore practitioners will continue to grapple with the sorts of issues that have arisen recently. So, for example, if there's been a failure to undertake an appropriate assessment because it's been overlooked, or perhaps because there's been a failure to undertake an appropriate assessment because of the state of scientific knowledge at that time, or even just simply because it was screened out at the decision at the outline plan permission stage, but something's changed. In those sorts of circumstances, the effect of the Supreme Court's decision is that Regulation 63 and the need for an appropriate assessment can still be brought back in at a later stage, namely the reserved matter stage or discharge of conditions stage, where the habitat regulations apply directly. And it also leaves open a slightly less satisfactory category of case, such as earlier cases like Swire, where even when there's been an appropriate assessment at an earlier stage, it doesn't rule out, and Swire is an example of this, it doesn't rule out the potential need to revisit that decision if there's been some sort of material change in circumstances. In that case, a change in natural inlands advice on a particular European site. So they're the sorts of practical problems we'll continue to need to grapple with in light of the Supreme Court's decision.
Thanks very much, Matt. The topic that I wanted to just spend a couple of minutes going over relates to what was defined as issue 2, ground 2 in the Supreme Court. And it relates to the approach taken to something that Charlie alluded to earlier on in his introduction, which is what matters are capable of being material considerations when it comes to decisions on reserved matters consents or the discharge of conditions pursuant to reserved matters consents. Because you'll remember from what Charlie said just a few minutes ago that the Secretary of State's contention in this appeal was that the scope of things that could be material was pretty wide at that stage. In fact, it was just as wide at the conditions stage or the reserved matters stage as it was right back at the original decision-making stage. And because of that logic, because of that premise, that brought in the entirety of the NPPF, the PPG, anything that Natural England have had to say by way of letters, post-consent, or anything else that's capable of being material to the original consent. All of that stuff, so said the Secretary of State, was capable of being brought back in again for reconsideration by the local planning authority when it comes to conditions or reserved matters. Now, lots of the issues that are given rise to on the facts of this case, as Ashley's going to touch on in a minute, may in one way or another be touched on, dealt with, or evolved through the Planning and Infrastructure Bill. More on that in a minute. But here's something that definitely won't be disturbed by whatever it is that ends up in the Planning and Infrastructure Act when it becomes law. And that is the Supreme Court's finding on ground 2, which is that when an outline planning permission or a planning permission subject to conditions is granted, it confers rights. Those rights crystallise at the point of the grant of planning consent. And it is not open to local authorities or to inspectors down the line when considering discharge of conditions pursuant to that permission or reserve matters following that outline permission, if it's outlined, to reopen the full cascade of other material considerations that fed into the decision to grant permission in the first place at the stage of a conditional discharge or whatever it might be. This is a really, really important point, a fundamental principle that goes, has implications across the field, as far as I'm concerned. And it's clearly right, and it's orthodox, and it's sort of remarkable, really, as part of the story of this CG Fry case, as it's moved, as Charlie said, through so many courts, that it took the Supreme Court to say it. The key point is that when planning permission has been granted, there is a fundamental change in the legal position. A grant of planning permission means that you, as a developer, as a recipient of that permission, have the right to proceed with the development that is described in your permission, and to develop in accordance with that permission. And obviously, if the authority or the Secretary of State is interested in modifying or revoking that permission, well, there are statutory ways of doing that, but they involve compensation. It cannot be a sort of backdoor revocation or backdoor modification by way of bringing in lots of extraneous matters at the stage of considering discharge of conditions. And as Charlie said earlier on, and it's absolutely right, and it's orthodox and critically important, rights that are set down in law. So by law here, we're talking really about the Town and Country Planning Act of 1990 that confers these fundamental rights that flow from a planning consent. Rights that are set down by law cannot be diluted by policy or indeed by any other sub-legal material considerations in the process. So it's really, really important and indeed of wide fundamental application, I think, to our understanding of the way that planning works, full stop. That the scope of what is up for debate when it comes to discharging a condition or looking at reserved matters is fixed not by Section 38(6) of the 2004 Act, but the other material considerations at large, but it is fixed by the drafting of those conditions that pertain to the original consent in the first place, because it's from there that the LPA derives the authority to make a decision in the first place. That sets the scope of what the determination is all about. And it belies in the end what was a fundamental misunderstanding by the Secretary of State, in this case by the inspector, of those matters that were capable of being material to the determination of the discharge of conditions and reserved matters. So a really interesting, from my perspective anyway, a really interesting point that led to the upholding of the appeal on ground 2 of really wide application across the industry. With that, I'll pass over to Ashley to tell us about how all of this is going to change.
Thanks very much, Zach. And finally, I was going to deal with the Planning and Infrastructure Bill, which is currently being debated in the building in which I think you, Charlie, are currently sitting in. So right up to the minute stuff. And there's some good news and bad news. The bad news, I think, certainly from the perspective of those wishing to see the government's ambition for 1.5 million new homes to be delivered throughout the course of this Parliament. The bad news for those people who think that's a good idea is the proposal at Schedule 6, as currently drafted of the bill, which is effectively to elevate Ramsar sites to an equivalent status to European sites by amending the habitat regulations. So the basis on which CG Fry was successful would be overturned by Parliament legislating in that way. And that would be that, unlike the position as it was before the inspector and before the Supreme Court, which is that the Ramsar consideration was relevant only as a matter of policy, this would be a mandatory binding legal obligation, which, because of the manner in which the Supreme Court has interpreted the habitats regulations, would bite at every single phase of anything that could be considered an approval or agreement to the project. So reserved matters, conditions, and potentially any other extraneous approval that's required for the proposal to commence. So it would increase the pool of sites that would be caught by the habitat regulations rather than decrease them. So that's the bad news for the realisation of the policy commitment, the manifesto commitment for 1.5 million new homes across this Parliament. The good news, however, is Schedule 4 of the Planning and Infrastructure Bill, which is clearly a way through this impasse, and that effectively provides that if the relevant habitat or species is identified within an environmental delivery plan and the developer pays the nature restoration levy, then the relevant elements of the habitats regulations are effectively switched off. If it's a habitat, like in the CG Fry case, what that means is that the obligations not to grant planning permission are to be disregarded. If it's a species, then the relevant species licence is treated as having been issued. It also overrides other schemes of protection, like protection of Badgers Acts and SSSIs. This is obviously good news. If the government stands firm on these provisions, it's pretty worthless and just an increased bureaucracy if that key provision is not adopted ultimately. It's notable the government has already slightly amended the wording and has acceded to some pressure to change it from sufficient, likely to be sufficient to outweigh the negative impact, to will definitely outweigh the impact. But provided that remains as it is, that's clearly positive. Obviously good news. This is clearly a sensible solution to a strategic level problem. It's not, however, potentially such good news if the EDPs take a long time to be adopted or they're legally challenged. So the key message is for the government to stand firm, to make sure that that provision is adopted, and that they then, once they're adopted, get on and get the EDPs in place.
Thanks, Ashley. A couple of thoughts based on that. And firstly, in relation to the Planning and Infrastructure Bill, Clause 90 and Schedule 6, which would extend the habitats regulations to apply to Ramsar sites, even though the Habitats Directive, the parent EU directive, doesn't apply to Ramsars. I think it's not yet a foregone conclusion that will make its way into the Planning Infrastructure Act. There have, in fact, been this afternoon amendments tabled by the opposition to exclude those provisions, and it does sit rather uneasily with the rhetoric coming from Number 10 in the Treasury in recent months about streamlining environmental regulation in the planning context, backing the builders, not the blockers, etc., as is said by politicians. And it does seem to cut somewhat against that, to extend gold plate regulation which is intended to apply the EU Habitats Directive to other areas, including Ramsar. So it'll be interesting to see what happens in the next few days in relation to that. Zack, in relation to material considerations, I mean, I suppose a paradigm case, do you think, is when the Environment Agency has changed the flood risk zone maps, as it has done, including last year. And I'm sure you, like me, have been asked by clients to opine on what that means in the context of reserve matters, particularly if the drainage strategy has already been agreed, or if there's a flood risk assessment baked in. So I think that aspect of the judgment certainly makes life easier in that sort of situation.
Absolutely agree.
A third point, I think one can't really conclude this webinar without sparing a thought for there's particular small and medium enterprise businesses, house builders, promoters in the Somerset Levels area, whom the LPDF and HBF evidence before the court said had been crippled by this issue, having acquired sites, potentially entered into construction contracts, obtained finance for developments, only to find at the stage where they were having to get approval of the colour of the doorknobs and the sort of materials of the window frames, that the whole thing was stopped for several years. And some of those sites have now been released owing to nutrient neutrality solutions coming along. They've often paid hundreds of thousands, if not millions, sometimes at the expense of affordable housing. So I think some questions have to be asked about how and why it took so long to get the right outcome for those people, and what potential remedies they may have now.
All good points. And thank you very much for everyone for tuning in. And obviously this is the beginning of what I suspect will be quite an extensive conversation across the industry about this case and its very interesting implications, not least in like the things Ashley was talking about and the emerging progress of the Planning and Infrastructure Bill. But thank you, Charlie, for hosting us, and very good evening, everyone.
Good evening. Great to work with you all. Thank you.